Good evening all. Welcome to another video with PRATHAM Test Prep. This is Sushila, your host. Today we will be discussing NCPCR's guideline for conducting preliminary assessment for child offenders. Now NCPCR has issued guidelines for the first time for conducting a preliminary assessment to determine whether a child should be treated as a minor or not in a criminal cases. So these guidelines came after the suggestion of Supreme Court. Supreme Court, while deciding the appeals filed in the case of murder of a 7-year-old student in which his another student was accused. The appellants approached the court challenging the direction of Punjab and Haryana High Court to conduct fresh preliminary assessment for the juvenile who has been accused. Now, bench comprising Justice Dinesh Maheshwari and Justice Vikram Nath held that when Juvenile Justice Board does not compromise of a practicing professional with a degree in child psychology or child psychiatry, the Juvenile Justice Board has to take assistance from experts such as psychologist, a child psychologist or a psychosocial worker. The bench also noted that preliminary assessment is a very delicate process and appropriate and specific guidelines are needed in this aspect. Hence, the bench suggested the central government, National Commission for Protection of Child Rights and the State Commission for Protection of Child Rights to come up with guidelines to facilitate the Juvenile Justice Board in making preliminary assessment. Now, to understand these guidelines, first we have to look into the significance of NCPCR and how the juvenile justice system in India has evolved so far. So, NCPCR, National Commission for Protection of Child Rights, was established in March 2007 under an Act of Parliament under the Commission for Protection of Child Rights Act 2005. Now, the Commission mandates is to ensure that all laws and policies, programs and administrative systems conform to the vision of rights of child as enunciated in Constitution as well as the UN Convention of Rights of Child. The main functions of NCPCR is to examine and review the safeguards provided by any law for the protection of child and to inquire into complaints such as deprivation and violation of child rights. Now the members, NCPCR has one chairperson and 6 members, and out of these 6 members, at least 2 should be women. And these members are appointed by the central government. Now, we come on to who is a juvenile, who is a child. So according to the law, current law in India, anybody who has not attained the age of 18 years would be considered as a child or a juvenile. And in this aspect, we'll see what are the rights they've been provided under our constitution. So Constitution recognizes and acknowledges children as equal to their adult counterparts. Children are given the same fundamental rights as their adult counterparts. There are 3 specific fundamental rights which are there for protection of children. The first one we are going to deal with is Article 15(3). Now, Article 15 prohibits discrimination. The clause 3 of Article 15 provides that legislature has the power to make special provisions for women and children. Now, we must focus that these special provisions does not mean that unequal treatment, but all they mean is to establish for the well-being and development of children in India. The next article is Article 21A. Now, Article 21A was inserted in 2002 and by the 86th Amendment Act. According to Article 21A, every child has a right of free and compulsory education and between the age group of 6 and 14. Now, the next article we'll be discussing is Article 24. Now, Article 24 provides for prohibition of employment of children in factories. Now, no child below the age of 14 will be employed in a factory, a mine, or any hazardous employment. Now, these hazardous employment also include your railways and construction work. It does not prohibit harmless work though. Now we come to next the directive principle for state policies. Now these are the principles set up on which the state is supposed to make laws and amendments and implement them. The first directive principle is given in Article 39E. So Article 39E deals with child labor. Child labor is one of those social evil that is forced by economic necessity. Responsibility of the state, there is a responsibility of the state to ensure that the tender age of children is not abused, and they are given in Article 39E. The Article 39E also ensures that they are not forced to enter into a vocation which is not suited for their age and their strength. Now, the next directive principle is given in Article 39F, which states that the state should ensure that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, protection against exploitation and against moral and material abandonment. Now, Article 45 deals with early childhood care and education. So, the children focused in Article 45 are below the age of 6. Article 45 states that a state shall protect the child and is responsible for the development within them, no matter what are the conditions of the child is. Even if they are protected by their own parents or they are denied the rights by their own parents, the state has to take strict measures to ensure that their early childhood care and education is taken care of. Nextly, we'll deal with fundamental duties. Now, fundamental duties are basic obligations of citizens of India. In total, there are 11 duties, and out of these 11 duties, there is one which deals with duty of a parent or a guardian to provide education and opportunities of education to his child between the age of 6 and 14 years. Now, this duty is for the future and development of India. Now, next we deal with the juvenile justice system in India. To understand this, firstly we'll have to understand who is a juvenile. Now, a person who has not attained the age of majority, right now it is 18 years. So, anybody who is below the age of 18 years would be considered a juvenile in India. A juvenile delinquent is a juvenile who has committed a crime. Now, delinquency is an action, a omission, or a moral behavior of a juvenile which is not permitted by the society, and when a juvenile does such an act, he is considered as a delinquent. Now, before the 19th century, there was no concept of juvenile justice in the whole world. Children were considered as young adults and were tried as adults only. Children who were above the age of 7 were sent to prisons also instead of reforming. So, what this did was that they learned more about the crimes rather than reforming. Then many countries later on realized this and started creating reform schools and work farms. US made the legal history in 1899 when they created the first juvenile court in Chicago. Now, if we come to India's view on it, till 1960, India did not have any unified law, any consistent law on Children's Act. Different states had their own laws. So, for example, Bombay Children's Act 1948 considered a boy who has not attained the age of 16 and a girl who has not attained the age of 18 as juveniles. But in 1959, India became signatory to UN Declaration of Rights of Child, and Children's Act 1960 was introduced. It was the first unified law. And according to the Children's Act 1960, anybody who has not attained the age of 14 would be considered as a child. Later on, UN minimum rules of administration of juvenile justice was adopted, and hence we had to replace the Children's Act with Juvenile Justice Act of 1986. In this act, any child, and specifically any girl child who has not attained the age of 18 years and a boy who has not attained the age of 16 were considered juvenile or a child. Later on, UN Convention on Rights of Child came in 1989. It was adopted in 1989. According to the convention, anybody, gender being no bar, anybody who has completed the age of, who has not attained the age of 18 years would be considered as child. And to implement this law, Juvenile Justice, Care and Protection of Children Act 2000 was introduced. Now, in this act, maximum punishment to be given to a child was 3 years, and that was also in a reform home and not in regular jail. The act focused majority on rehabilitation of minors. The Juvenile Justice, Care and Protection of Children Act 2000 also introduced Juvenile Justice Board. The aim of the board was to hold a child culpable of their criminal activities, not through punishment but through counseling them, so to understand the actions of the child and to persuade them to stay away from criminal activities for future. Now, the scenario in India around 2012 changed as there was seen a rise in juvenile delinquency that 30% rise in crime period from 2012 to 2004, and 70% of the children accused were between the age of 16 and 18 years. The main focus while changing the law was that the act of Nirbhaya gang rape case, in which there was an involvement of an accused who was 6 months short to attain the age of 18 years. Now, legislature was later on forced to replace Juvenile Justice Act 2000 with Juvenile Justice Care and Protection of Children Act 2015. Now, if we look at the key features of this act is currently in force. So the key features are very important. The act characterized children into two categories. Firstly, child in need of care and protection, and secondly, child in conflict with law. Now, who is a child in need of care and protection? Any child who is without a home, or is working in contravention of labor laws, or resides with a person who is unfit to take care of the child or has put them in danger. Now, child in conflict with law, anybody who's below the age of 18 years who has come in contact with the justice system as a result of being suspected or accused of committing a crime. The Juvenile Justice Act of 2015 also categorized three offences into three categories: petty offences, serious offences, and heinous offences. Now, petty offences are the offences in which the maximum punishment is 3 years. Serious offences are the offences in which the minimum punishment is 3 years and the maximum it can be is of 7 years. And heinous offences are acts which are punishable by 7 years or more. Now, initially, all the children before this 2015 Act, all the children were till the age of 18 were dealt in the same way. But the Act of 2015 called out a separate category for juvenile between the age of 16 and 18 years who were involved in heinous crimes. They were subjected to preliminary assessment to check if they are to be tried as children in Juvenile Justice Board or as adult in Children's Court. Now, the preliminary assessment basically tests a child on 4 aspects: physical capacity, mental capacity, circumstances in which the offence was committed, and ability to understand the consequences. Now, physical capacity is to determine the locomotor abilities, particularly the gross motor locomotor abilities such as running, picking, throwing, lifting, etc. Secondly, the mental capacity. Mental capacity assesses the ability of a child to take social decisions, and if they are suffering from any mental health disorder or substance abuse or any other life skill deficits that they may have. The third aspect is circumstances in which the offence was committed. Now, these are the psychosocial vulnerabilities of the child would be inspected, the life events that has happened to him, any trauma, abuse or mental health problems that the child might have, as an offence behavior is a cumulative of consequence of a lot of other circumstances. Lastly, the ability to understand the consequences were tested. Now, these are to determine if the child's knowledge regarding the act they have committed and what social, interpersonal or legal consequences they might have. It also tests how a child would be treated or perceived by others. Now, let's come on to the new guidelines that has been issued. Now, these are the key points of these guidelines. So, Juvenile Justice Board, according to what has been held by the Supreme Court, the Juvenile Justice Board shall be responsible for preliminary assessment, and it shall provide the child and child's family and their counsel a copy of order. Now, Juvenile Justice Board also should take assistance of psychologists and experts. If they do not have experts associated with them, they'll have to take assistance of experts from outside, and they have to have the required qualification to assist the JJB and to undergo a training concerning Section 15 of Juvenile Justice Act. The child should also be provided with legal aid counsel through the District Legal Service Authority, who shall be present during the preliminary assessment. And lastly, during the preliminary assessment, the board shall also analyze and take into consideration social investigation report which is created by the probation officer or the child welfare officer. So as per, like we can see, as per the reports, the PA, that is the preliminary assessment, decides whether the accused would be tried as a child or an adult. Such assessment can't be conducted in a routine manner, and it requires a meticulous psychological assessment of the child. So that's all for today from our side. Thank you so much for being a part of this live.